Thank you all for coming this evening to this CPD about submissions for the junior bar. Usually at this time of year, people attend CPDs as an attempt to get the last points they might need, but I'm confident that the draw card tonight is in fact our speaker and this incredibly useful topic. The Honourable Peter Applegarth has had a career far too distinguished to be fully captured in a few sentences. Justice Applegarth practised as a barrister for 22 years, practising in a wide range of civil and public law litigation before being appointed to the Supreme Court of Queensland in 2008. During his judicial career, His Honour served as supervised case list judge, commercial list judge and principal commercial list judge. His Honour's contributions to the law and the profession extend beyond the judiciary. They include serving as chair of the Queensland Law Reform Commission, lecturing part-time at the University of Queensland and holding board positions including for Legal Aid Queensland and UQ Pro Bono Centre, to name just a few. His Honour was appointed a member of the Order of Australia in 2020 for his significant service to the law, judiciary and social justice. His Honour has told me that since retiring from the court in 2025, he now prefers to be known as Peter, and he proudly takes on the role as grandfather to his 3 grandchildren. Much to our fortune, Peter is now devoting significant time contributing to the profession by teaching law and advocacy, including through the bar course, the ABA's Advanced Trial Advocacy course, and giving CPDs like this one. We are incredibly grateful for Peter's generosity with his time and in sharing his incredible knowledge and skill. Peter also spends his retirement, as he's calling it, conducting arbitrations and mediations, and he is a PhD candidate at the University of Sydney. On that note, I will stop speaking and hand over to the person you've all come here to hear from this evening. Thank you, Peter.
Well, thank you for that excessively generous introduction and perhaps overselling the product. In the era of artificial intelligence, there's a tendency to treat judges as decision-making machines and to compare them with artificial intelligence. And in some respects, some of the bodies I've been on have considered AI as an alternative form of judicial determination. Well, in 1931, the great professor and jurist Jerome Frank wrote an article headed, "Are Judges Human?" And he came to the startling conclusion, we have to face the fact that judges are human. Advocates are human too. And it's only natural that advocates, particularly junior advocates, when they're appearing in front of a judge, perhaps a judge for the first time, want to immediately impress the judge about their command of the brief, that they know all the facts and they've read lots of cases. And so the first couple of minutes are blah, 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 that you're going to impress me with just how much you know. And that's understandable and it's good. And judges would like to know the facts, they'd like to know the law, but they don't necessarily want to know it all in the first 2 minutes. When I was a junior barrister, I had the privilege of appearing in front of some incredible jurists. To name one, there's a guy called Bill Pincus who's on the federal court. He was so clever, I thought he had 2 brains. He had more processing power than my Mac SE30 at the time, which had a maths code processor. He could just absorb a lot of information, get on top of the case, get to the point. And I would marvel at his capacity to process a lot of information. He had a big brain, but even someone with a brain as big as Bill Pincus can't process too much information. What a judge wants to know, a judge or a when I say judge, I mean judge or a magistrate, wants to know at the start are the essential facts, and what the issue or issues are in the case. They want to know that early. And give them a whole lot of facts and a whole lot of law too early doesn't enable them to know the essential facts. So what I want to talk to you tonight about is the opening and, more pertinently, the idea of issue framing, and you'll see the points that I'm hoping to cover. We remember really good opening lines of pop songs, poems and novels. People tend to remember memorable openings. And so the task is to make your opening, whether it's the first few minutes of an oral submission or the first paragraph of a written submission, memorable. And the opening is what you might say is valuable real estate. And so if you're turning up in an ordinary sale of goods case for about a breach of contract, you might assume, whether your assumption's right, that the judge has read the submissions that might be on the file or read some of the material. And there's a temptation to assume the judge knows a reasonable amount and then to start, would Your Honour turn to Exhibit JC 32, the affidavit of Jackie Charles, and you'll see at the bottom of page 245, clause 17.4G, and you start to read. So you're helping the judge, and that's good. But the judge will probably already know if they've read the submissions, that's the clause. And you don't need to go to clause 17.4G at the very start. What you have to do is keep it short and simple. And in that type of case, you say, the defendant promised to deliver 275 widgets to the plaintiff by April 17. The defendant failed to deliver on time. Widgets were delivered on August 1, but they're gravely defective. The plaintiff couldn't use the widgets to commission the new facility. The defendant's breaches caused the plaintiff great loss quantified at 2.17 million. You've summarised the facts. You didn't need to set out clause 17.4 at that point. If you're for the applicant, the plaintiff, you might want to preview the defence. And then you say the only real defence here is that the written promise to deliver on April 17 was varied, but that defence is feeble. The contemporaneous documents show the parties always proceeded on the basis of an April 17 delivery date. So fact, then the issue. Can the defendant prove, on the defendant to prove a variation, can the defendant prove, contrary to the contemporaneous documents, that there was a binding oral agreement to vary the delivery date? And what you just said about the absence of contemporaneous support tends to suggest the answer. So you framed the issue at the start. Well, what is issue framing? Remember, we do different kinds of work. A lot of your work, opinion work, is not persuasive writing, it's analytical writing. But whether it's analytical writing or persuasive writing, any piece of writing has to identify the question and the answer and the reasons for that answer. And it only works if you open with a factually specific issue that captures the essence of the problem. And that's what we mean when we talk about issue framing. I only heard the word issue framing when I was senior counsel and Justice Ayn gave a paper about the new High Court practice rules. I'd never heard it before. I went off and looked up a dictionary and saw what it was. But it's a topic that features in a lot of writing. And the guru, the god of issue framing is Professor Brian Garner, an American, unsurprisingly. And he's written extensively about this. So you put the issues first. He doesn't like people who start, the issue is whether. He doesn't like that. Other people don't mind it. But you've got to break it up into separate sentences. Typically, statement of fact, maybe a statement of the rule, then the issue. So, maybe 4 sentences, try to keep it under 75 words. And to do that, you have to strip out all the extraneous facts. You might have to come back to those facts later in the middle, but at the start, you don't want extraneous facts. I've been guilty of this as a barrister and a judge. It's usual to start. This is an application under, Section 36 of the Dog Act, or this is an application under Section whatever of the Constitution. That's great. But if your next door neighbour, as you're walking off to work that day, said, what's your case about today? You wouldn't say, I'm bringing an application under Section 32 of the Dog Act. You'd say, the defendant's dog bit a child. It's not the first time the dog's bitten someone. I'm applying for a dangerous dog declaration. And you wouldn't tell your neighbour that's under Section 36 of the Dog Act. You'd start with the facts, who did what to who. But as a judge, I would hate to think that I would extend judgment by saying this is an application under. So I'm telling you what to do. I'm not saying I did any of these things. But you have to tell a short story. There has to be a factually specific context in which the issue is raised. And Felix Frankfurter famously said, the right answer depends on putting the right question. And the whole point of this is if the judge accepts the way you frame the issue, might only be one issue in the case, there might be 4 issues in the case. You know, was there a contract? What was terms? Was it breach? Did it cause a loss? Some cases have 5, 7, 22 issues, but some only really have one. But if the judge accepts the way you frame the issues or the issue, the case is really half won. And the famous jurist and academic, Professor Carl Llewellyn, in 1962 wrote a famous article about appellate advocacy. And he said the first art is framing the issue so that if your frame is accepted, you win. Second, you have to capture the issue because your opponent will be framing an issue very differently. And I'll come back to this later. I talk about reframing. If framing the issue your way helps you win the case, you've got to make sure as an opponent that you say, no, that's not the issue. This is the issue. So there's framing and reframing, competing framings, but you've got to make yours the most captivating. And it's got to be such that it captures the court's attention and it'll stick. All this is part of thinking about what judges want and what they expect. Now, judges hope for brilliance. When you see brilliant advocates, young or old, it's terrific. But if you can't get brilliance, you want assistance. Judges are time poor at all levels of the judicial hierarchy. And when I talk about the judicial hierarchy, when I was a Supreme Court judge and you'd go on circuit to Toowoomba or somewhere, you'd be in the same building as the Magistrates Court and you'd see the domestic violence list and they would have 50 cases. DVs, breach of DVs, they'd have 50 cases in a morning. And I used to think I was hard done by if we two judges in the applications had 25 cases. I'd have to do 12 cases in a morning or a day. And you might think, those High Court judges, they only really have to, write 50 judgments and 50 important judgments in the year. They've got plenty of time to think and, cogitate. But they're busy writing judgments. They're busy dealing with special leave applications on the papers and the like. They're all busy. Justice Edelman's, up at 4 o'clock in the morning as editor of McGregor on damages. So he's busy writing papers. Everyone's busy. So people at the top of the food chain who are looking at a whole bunch of applications for special leave on the papers, you need to get their attention and you need to grab them. This is the issue. And it's an interesting issue. Now, the High Court, in their practice directions, they more or less require you to state the issue. It's compulsory, but why wouldn't you do it anyway in a tribunal, magistrate's court, wherever you are? So, as I said at the start, the judge wants to know the essential facts, the issue or issues, what the relevant rule or principle is, distill that down as well. the result you contend for, the orders you seek, sometimes that's a bit vague, and of course the reasons why that result is justified, and importantly, why the other side's arguments aren't persuasive. It's all well and good beating your drum, but at some point, and there's no necessarily decisive point when you do this, you could do it at the start, you could do it at the middle, you do it at the end. Every case is a little different. You've got to engage with the other side's arguments. Now, you might be wondering where that beautiful building is. That's actually a courtroom. And in 2015, I went there. It's an appeal court in New York City. It's not the famous one in Albany, but it's effectively the equivalent of our Court of Appeal. And they do appeals on murder cases and large commercial cases. And it had a list of appeals, there were about 18 appeals, and they started at 2:15 in the afternoon. And I thought, how are they going to do this many appeals? And people had estimates that said, 12 minutes for submissions and 5 minutes in rebuttal. And the 5 judges came in, the presiding judge named 20, said, with these estimates, we're going to be here all night. I want revised estimates. And I actually had this piece of paper written down. And I'll be 5 minutes and 2 in rebuttal. And it's almost like a gong there. When the 5 minutes is up, gong, you're done with. And I was amazed at the skill of these advocates to present their case in 5 minutes. But that's the skill that they had to acquire to appear in that court. Written submissions are important. They're the raw material for any judgment. And when I was a judge in busy applications list, you just couldn't reserve too many judgments. And whether it's a bail application, applicant submissions or response submissions, you should be highlighting things, mapping it out. And they're the raw material for judgments that I just give straight off the bat. So they're very important in terms of their readability, accessibility, identifying the issue. So that's what they have to contain. Framing the issue, statement of the relevant facts, not too much, and including facts that don't help your case, because if you don't refer to them, the other side's going to do it and they're going to go, well, a learned friend didn't refer to this evidence, so there has to be some element of warts and all. And you've got to capture the rule or principle. It mightn't be terribly controversial, but you capture that without having huge slabs of quotations from cases. But there's just a task of persuasion. Now, I want to spend a little bit of time talking about ways in which we frame issues. And this is what Garner would refer to as deep and surface issues. And I imagine I would have been guilty many times. If someone asked me what the case is about, I'd say, well, it's about whether the defendant engaged in misleading, deceptive conduct when they, sold shares or whatever. And you'll see that kind of framing. And in submissions, you might say, oh, the issue is whether the respondent engaged in misleading or deceptive conduct when it sold a fish and chip shop. Well, that's the issue. No doubt that's the issue. But it doesn't tell me very much, doesn't tell anyone very much. And as I said, it's not just the applicant who frames the issue. In that type of case, fish and chip sale cases, the respondent will want to frame the issue. And I've done that there in 66 words. If you can't read it from where you are, I'll just read it quickly. The respondent told the applicant about the trading history of his shop. He said nothing about future earnings. What he said about the trading history was indisputably correct. The applicant made assumptions about the shop's turnover under his new management. These turned out to be too optimistic. Fact, 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 fact. Hope I can prove all those things. Fact, 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 fact. I'm not setting out Section 18 of the Act, corporation not engaged in conduct misleading or deceptive. We just all know that. Fact, 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 fact. Can the respondent be said to have engaged in misleading or deceptive conduct when everything he said was true? It's sort of almost like a rhetorical question suggesting the answer. But that's framing it from the respondent's point of view. Now, Garner says, and I think this must be right, you just don't write it in all one big sentence, once upon a time, da 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 da, and under the, you have to break it up into digestible sentences. There has to be enough to tell a little story. You don't include unnecessary detail. You don't say by a contract entered into on the 22nd of April 2022, the respondent agreed to sell and the buyer agreed to buy a fish and chip shop situated at 123 Enmore Road. Like, don't know why you need to refer to that. You don't need to refer to Enmore Road. You don't need all that stuff. It's the same thing as the clause 17 of the widget contract. You don't need to set out the contract. He agreed to sell 275 widgets and deliver them by April 17. Of course, you've got to develop the facts and the argument later. And as I said, in many cases, there'll be more than one issue and you're framing it with a question. And as I said, there's the counterframe. And there's just a simple example from one of Garner's books of issue frame that's stating the rule first that in Missouri, a deaf person is arrested entitled to a licensed certified interpreter. Doesn't say under clause 27 4B of the Disability Act of Missouri, quote, just states what the law or the rule is. Then it just tells a short story. Joe Pearson, deaf person, was arrested for driving while under the influence. Police retained an unlicensed, uncertified interpreter to talk to Pearson. She interpreted Pearson's words as refusing a breath test. Can this court revoke Pearson's licence based on the uncertified interpretation of an uncertified interpreter? Tells a little story, frames the issue, suggests the answer. I think there's two problems why we don't issue frame. One is we're just used to dealing with that big surface issue. Did the respondent engage in misleading, deceptive conduct, rather than something more factually specific? The other is over-particularisation, that in writing you're saying, almost starting, once upon a time, by a contract entered into on whatever, telling a story, weaving in, telling a story, then you'll get around to a bit of law and by its defence file on whatever, the defendant raised 3 defences and then at about page 7, the issues kind of bubble to the surface. And that's the problem of over-particularisation, that you've said too much. You're just writing, as Garner would say, in the middle. All that stuff about the date of the contract, what it provided, what the law is, that belongs in the middle. The submission's got to have a middle, but they've got to have a start. And they've got to have an end. Now, why do we engage in this over-particularisation? Why don't we just issue frame naturally? Well, by way of confession, and I guess most people are like this. When you're at university, you had an assignment, you had too much going on in your life and the assignment was due and you'd pull an all-nighter, or even if you didn't pull an all-nighter, you were organised and you spent a day or two, reading the stuff and reading the cases, and you might have jotted down a few notes, but you kind of had it in your head. And then in my days, before the invention of the computer, you had a blank page, but in your days you have a blank screen. And you got in your head, I know what it's about, I've got a structure in my head, and I'm just going to blast away because I've got this worked out in my head. And that's how we do a lot of our writing. and it's just natural. We've got a few scrappy notes. We've got a rough plan, very rough plan. Now, this is a writing problem. It's not just a legal writing problem. Whether it's Mark Twain or Henry David Thoreau or Blaise Pascal, they all made the same point. If I'd had more time, this would have been shorter. And in my valedictory speech, I sort of said the same thing. I'm sorry that all my judgments are far too long. If I'd had more time, they would have been shorter. I would have cut out the repetition. I would have framed them better. When you're a judge, you can take yourself off to a judgment writing class, which is taught by some judges, some retired judges, but also by professional writers. I went to one at a conference hotel at Brighton in Victoria after I'd been a judge for a few years, and they said, bring along a couple of your recent judgments. And the first task you had to do was overnight rewrite the judgment so there's 30% of its length. And you could do it. And I had Gideon Haig as my tutor. He was a great writer, and he actually thought this case was interesting. I thought it was a really boring case, but editing takes a long, long time. And that's just a problem when we blast away. And we never have enough time. And the problem, I think, arises because we compress what has been described as 4 writers into one. There's an American literary professor, and she came up with these tasks, the madman, the architect, the carpenter, and the judge. And when you're just blasting away, you're doing the task, the madman, the architect, and the carpenter all at once. The madman thing's important because, you know, you've been writing down this and you've got all these ideas, thoughts. Once upon a time, there's a thing called butcher's paper, you know, big white paper that you write stuff on. That was replaced by whiteboards. I'm sure there's electronic equivalents of whiteboards. But you know what I'm talking about. Just any ideas, you might be in the right sequence. Some of these ideas might be crazy. You might think them through and they don't work. But you've just got to put down all your ideas somewhere in some form. And then you put on the architect's hat. And a lot of cases just have their, you know, obvious logic. Was there a contract? What were its terms? Were the terms breached? Did the breach cause damage? They're just a logic. It's like building, you know, a shack with, you know, 5 bedrooms, you know, front porch, issue framing, first shack. You know, was there a contract? First room. We're building a series of rooms, so there's each of these. But within each of them, you've got to be referring to the evidence, the rule, your arguments. And so you'll have a very rough plan, but investing some time on writing a more detailed plan is useful. So there's planning, but then there comes the point where you have to pick up the tools, and whether it's one of these plastic fountain pens or a really good fountain pen, or a keyboard, there's just the pure writing. And of course, carpenters work off plans so they can concentrate on the task at hand. I've got to cut this to this length. I've got to do this. I've got to do that. And if you've got a fairly detailed plan, you're going to be writing a lot better. You just going to be thinking about the writing process, not what issue comes next, because the issues that come next are on the page of writing to a plan. And then you go back, and the judge is not a really good description. It's not a judge like I used to be. It's someone who goes back and go, you know, that could be 2 sentences rather than 1. That could go here. That'd be a more powerful word. And doing the kind of fine tuning and indeed the proofreading. One of my heroes, Justice Louis Brandeis, once said there's no such thing as good legal writing, only rewriting. And the heavily edited thing on the slide isn't a piece of legal writing. If you go a bit closer, you'll see how heavily edited it was. Just to see, that's the first page. That's the first page of 1984. So all didn't sort of crack the first page on his first go, he rewrote, and he was dying as he wrote it and rewrote it. The problem is we're all time poor. It's all well and good for Louis Brandeis. Those guys weren't as busy as any of us are, and he would have the time to write and rewrite. And if you don't efficiently figure out the issues, have a plan, you'll spend an inordinate amount of time rewriting, and we just don't have that time. I know from bitter experience that sometimes when I was writing judgments, so long ago I can't remember what it was like when I was a barrister, but I think it might have been the same problem because I came from that sort of dictation generation. But when I would dictate my judgments, I would dictate them off effectively handwritten notes. But sometimes when I thought I had something I was too busy, you just sort of, I've got this, and it's a flow of consciousness stuff. And the dictation flow of consciousness stuff is the same equivalent of the non-dictation generation of just going, I've got this and here's the story and I'm an artist and it's all going to be okay. And if it's no good, I'll just edit it and I'll fix it up. But the fixing up just takes so much time. And you say, I should have spent 45 minutes planning this rather than spending 3 hours rewriting it. So the rewriting thing is inevitable. We always improve. All of my judgments could have been better if I'd had more time and I'd rewritten them or improved them, but we just don't have that time. So a lot of this isn't about legal writing, it's just about writing. And you'll find some people love using, Norman words when Anglo-Saxon ones will do. Use a short word if you can. Make issues concrete. Don't slab out long passages from judgments, but if you have to set out a substantial bit, highlight the bits that are important, emphasis added. Phrasing is important. I'm not a great writer, but I've read lots of good writing. And a sentence, the most important word in the sentence should either be at the start or the end, and the sentence not buried somewhere in the middle. As I've said, avoid unnecessary detail. You've got to give your reasons, counter-arguments, and you've got to close powerfully, I think. Not everyone would perhaps agree with that. So a lot of this is just the rules of writing. Now, if you've framed the issues at the start, if there's 3 or 4 issues of the type that I gave some examples of, they are your headings. And they aren't was there a contract? It is, what do the contemporaneous documents show about the agreed delivery date? You have headings that are informative, not just neutral. They pose a question. What do the contemporaneous documents show about the agreed delivery date? And that's where you are in the middle and going, as necessary, quoting them, referring to the evidence. But you might just say, in none of the contemporaneous documents was there ever a suggestion of an extension of time to August 1. In fact, the parties consistently referred to an April 17 delivery date. And you just have a footnote where you could refer to, is there an affidavits, exhibits to affidavits, or in documents hyperlinks if you're running an electronic trial. You don't need to slab out all that evidence in your submissions. But that's how you do it. The key point is you've got a heading that's posing the issue, the factually specific issue. You should use headings to your advantage. So given that this is media law cohort, there was a defamation case where a West Virginian coal company, a West Virginian coal baron, sued John Oliver, the comedian. And I won't spend a whole lot of time, but you can see that the headings to that kind of capture what the issues are. And there's not many cases that you can kind of laugh a case out of court. It's a dangerous thing to do. I think it's super dangerous. But in its own slightly humorous way, a judge picking up that memoranda knows where they're heading because that's the table of contents. Now, you won't be using the word shit in your submissions, I hope. And you won't be referring to someone as Bob. But your table of contents and your headings should be telling the judge where you're heading. Now, engaging with the other side's arguments. Why in the world you'd resort to overheated, emotion-laden invective is just beyond me. It's unprofessional, it's unethical, and it's unproductive. If you're accusing the other side of, mischievous behaviour, and you don't need to say the other side's case is fundamentally misconceived. You just need to say that it's flawed. It's failed to engage with a certain issue, and analytically dismantling their case is far more effective, because the judge, if you say, oh, we're going to prove that this is a abusive process and that they brought this case knowing that it was hopeless, and why would you do that if you didn't have the evidence to do it? Why would you do it anyway if you don't have to do it? And damning your opponent's submissions with faint praise is much better than invective. Now, everywhere's different. I can remember I was at the bar, I appeared in a case in the federal court in Adelaide, and I said the other side's submissions were misconceived. And during an adjournment, the QC on the other side got me outside. I said, we don't use that sort of language in Adelaide. I said, you should go to Sydney. But you do have to engage with the other side's submissions and say what they fail to do. You may say they're unsupported by reliable evidence. They fail to engage with the issue of causation, or they fail to engage with this body of evidence, or they fail to engage with the principle that. So the flaw can be a failure to address and engage with a governing principle, that they just haven't had regard to this body of evidence, which is contrary to their case, or that they just blithely assume something like causation. So there's no one way or one place to do that. At the start, you might say there's three reasons why interlocutory injunction should be, let's say, granted, if the respondent say refused. And you give if you can. Could be three, could be four, could be none, could be a couple of reasons why the other side's case lacks merit. And in that kind of interlocutory injunction case, you'd be saying there's no evidence of this, or unless the respondent's restrained, the applicant will suffer irreparable harm. So every case fits, but in that interlocutory injunction case, the big issues are, of course, the strength. And if you've got a strong prima facie case, don't hide your light under a bushel. But it's usually a contest about irreparable harm. And you'd say, the only harm the respondent will suffer by being restrained is a delay into this market. On the other hand, unless restrained, the applicant's brand will be diminished by someone who provides an inferior service, and it'll be impossible to assess that harm and to adequately compensate it by way of damages. So every case is different. You just need to think up what are the flaws in the other side's case. And getting back to the point that judges are human, just think about what it means when you say, well, the applicant's argument about whatever may have a superficial appeal that doesn't withstand careful scrutiny. I hope that's not God thundering. If there's a lightning bolt, it's my fault. I've brought this upon us. And you say, this is the damning with faint praise. They've got a superficial appeal. Like the judge might have actually thought, when they read the episodes, oh, these are pretty good. Now, what are you saying when you say they have a superficial appeal? We're saying, Judge, you're not superficial. You're not a superficial thinker, you know. Yeah, it's psychology. I want to get back to the issue of reframing. And when I was a law student at Oxford in the early 1980s, this big case came out. There was some documents been leaked from British Steel Corporation and given to Granada Television. They ran some show. And British Steel wanted to find out who the leaker was and brought this proceeding as Granada Television to reveal its source. And this big case about freedom of the press and the like. And I was reading the appeal cases late one night in a library, and I got to the submissions of Mr. Hoffman QC, later Lord Hoffman. And this whole case being packaged as, this is a case about freedom of the press. And there in the law report, you can go and read it. He said, this case is not about freedom of press. The appeal raises the narrow issue of whether the public interest requires that a plaintiff should be denied redress against the person who has violated his duty of confidence by giving secret information to the media where A, the person who gave the information had no right to give it, the journalist who received it had no right to receive it, there's no excuse of public interest, and the absence of redress is causing the plaintiff serious and continuing damage. And I looked at it and I thought, that's absolutely brilliant. That's used a sporting metaphor, shifted the goalpost. This isn't about freedom of speech. And look at the language that's used. Denied redress, violated. Nice little word. So that's an example of reframing. Now, closing. Of course, I'm not talking about your closing oral submissions. They'll ideally have all these things about issue framing and the like. Yeah, up against page limits sometimes in courts. But I think most written submissions benefit from a short closer. Most end with a whimper for these reasons. The application should be granted, the application should be dismissed. They're a one-line conclusion. But whether it's closing oral submissions or short, very short closing submissions, you try to bring it together. Of course, you can't just open up a whole new argument, different arguments. The opening and the closing have to be consistent, but by the time you get into the closing, there's a bit more water gone under the bridge. The judge has understood the facts a bit more. There's a degree of persuasion has gone on. And so the closing statement can come at it from a slightly different angle based on all the stuff that's been written in the middle. Let's get back to the start. Remember what I said about that beautiful courtroom in Madison Avenue, New York, where they had 5 minutes and 2 minutes in rebuttal? Just imagine you only had 5 minutes to present your case. You wouldn't be saying by contract dated whatever and reading to the judge clause 17.4. You would be presenting your most persuasive points, and you'd need to frame the issue in the way that I've tried to explain. Now, here's the good news. You're not like those poor advocates in that court where you have 5 minutes. You'll be granted more than 5 minutes, I hope. But in a busy domestic violence case, in court or a super busy trial, you might only have 5 minutes. But in most courts, you'll have more than 5 minutes to open your case. And of course, you'll need to preview who the witnesses are and on it goes. But imagine that you only had 5 minutes to introduce the case, say what the essential facts were, and identify the issue, and at least engage in some persuasive framing of the issue. Imagine you only had 5 minutes. Well, that's your opening. That's your first paragraph or two on page 1 of your written submissions. They're the first 5 minutes of your opening. Then you go to Once Upon a Time and take the judge selectively to the relevant facts, those that help you, those that don't help you. So to bring it back, if you're in a criminal case and it's a barroom brawl and your client's charged with assault and he says he's defending it, he's acting in self-defence because the complainant threw the first punch. You might say, well, the issue in this case is self-defence. That's true. That's a surface issue. The real issue is who threw the first punch. And you wouldn't start off, sorry, I'm not too familiar with New South Wales criminal law, but I come from the Griffith Code state. You wouldn't start off by saying, under section 271, subsection 2 of the criminal code, there are 4 elements to the defence. That there was an unprovoked assault, that there's reasonable, and the defence will succeed unless the prosecution, blah, blah. You wouldn't give a discussion on the law because this case is either won or lost, depending on who threw the first punch. That's the issue, not whether a punch was excessive in responding to a punch. That's a non-issue. So why would you talk about all the other elements of a self-defence defence? That's the issue. And if you can embed, if it helps you, the onus of proof and the standard of proof in that question, well, that will help. Now, this might be anticipating what the evidence is going to reveal or emerge from the depositions. But if you're opening your case or even telling the judge is going to try the case the next day, what the case is about, you can rock up and say, the judge were trying to organise a list at the district court at Lismore. What's the issue? Issue self-defence. Thanks very much. That's great. But why don't you say to the judge, the issue is who threw the first punch? And if you have enough time, either at the preliminary hearing or when you open the case, you'd say the prosecution witnesses were drunk or otherwise in no position to reliably say who threw the first punch. A credible independent witness testifies that the complainant threw the first punch. How then can the prosecution prove beyond reasonable doubt that it was the defendant who threw the first punch? Fact, issue. Embedding the onus of proof and the standard of proof in the framing of the issue. The late, great novelist and author David Foster Wallace did a seminar with Brian Garner that was recorded and ended up in a little book. And David Foster Wallace said the cliche that writing appears effortless takes the most work has been borne out through very unpleasant experience. That's why people use terms like flow or effortless to describe writing that they regard as superb. They're not saying effortless in terms didn't seem like the writer spent any work. It simply requires no effort to read it. The same way listening to an incredible storyteller talk out loud requires no effort to pay attention. So really good writing doesn't show signs of effort, but the effort has been put in. I was a big fan of Lord Bingham. I still am. And he wrote an important dissent in one of these terrorism cases. And the issue there was administrative law context about detention and whether the state could rely upon evidence which the detainee said had been procured by torture and waterboarding and all this mischievous activities. And the issue, interesting issue, was whether, as it were, it was for the detainee to prove that the evidence was wrongfully obtained and shouldn't be relied on because, the accuser's testimony was procured by torture or other improper action, or whether the state had to prove that its evidence wasn't tainted that way. So it was a case that went to the House of Lords on effectively notice of proof. And Bingham was in dissent, but he said this about the test that the Secretary of State put up. This is a test which, in the real world, can never be satisfied. The foreign torturer does not boast of his trade. The security services, as Secretary of State has made clear, do not wish to imperil their relations with regimes where torture is practiced. The special advocates have no means or resources to investigate. The detainee is in the dark. It's inconsistent with most rudimentary notions of fairness to blindfold a man and then impose a standard which only the cited could hope to meet. Now, that's not a good piece of legal writing. That's just a good piece of writing. And I don't think he probably got it right on the first go, or he may have. But, the detainee is in the dark. Short sentence, punchy, beautiful metaphor, just good writing, and that requires effort. Getting back to the point I made at the start, judges are human. I mean, we have to decide cases according to reason, logic. Rationality is important. The logic of your argument is important. Showing the flaws in the logic of your opponent's argument is important. But there's also an emotional element to judging. And so there's, logos, pathos, ethos. And you've got to consider all of these characteristics. The fact that judges are human beings and have emotions doesn't mean that you should overblow the stuff about emotion. If your case is deserving, you're acting for a little old lady who's being choked to death by pollution, you don't need to get out the 1930s jury advocacy. The merits and sympathy will be with your client. You don't need to overdo it. You need to show she's got a viable cause of action. But judges are, perhaps subconsciously, affected by emotion. They are, after all, human. And my mentor and friend, Pat Keane, when he was a barrister in my chambers, used to say the High Court was the best jury in town. And, you saw, I saw as his junior, how good an advocate he and others were. Now, if you're not acting for the little old lady, if you're acting for the big belching corporation that's spewing particles into the air, you're not going to have a lot of sympathy from the judge, but you wouldn't be dismissive of the little old lady, and you wouldn't sort of say, oh, she's malingering and exaggerating, and you just wouldn't, unless you had an impeccable case in that regard. But your emotional appeal would be one of sorrow rather than anger. Anyone would have sympathy for the applicant's predicament. However, she doesn't have a legal claim for these three reasons. Showing a bit of sympathy, understanding is not bad, shows you're human, and might put something of a human face on your big bad corporation client. So think about emotional appeal, not overblown, overdone emotional appeal, but in your choice of words. Remember when Hoffman, in that reframe, used the word violated, didn't say breached. Words have impact. You saw that from any piece of good writing. That's when you go back, putting on the judge hat, improving the word. This word would have more punch. This word is a better choice of word. So all of these things are difficult. I'm just going to conclude with, how one can improve your writing and your oral advocacy. Well, if you're not in court, if you're not super busy, go to court and see the best. You don't need to go to court all day, but go and see the best. You know who the best are. Read the best submissions. They're there online in many courts. There are books about this stuff. You know, Brian Garner writes books and articles. Other people do it. And if there's one point I'd like to make, is you have to think about how judges think, that they're humans, they're not machines. Remember, too much information too early is not helping the judge. And I gave a talk to the bar practice course in Queensland, which I then rewrote into quite a long article, because the other thing I did in New York in 2015, I went to a seminar at the Federal Court, and Professor Daniel Kahneman, the author of Fast and Slow Thinking, a Nobel Prize winner for economics, gave a talk, and I swallowed the Kahneman Kool-Aid. And so I wrote this article about fast and slow thinking by judges and other human beings. So just remember, judges are human beings. Framing the issue for determination early on helps them. So it might be the thing that takes you a lot of time. You may spend 20% of your time on the first page, and you might get it right the first time. You'll write it and rewrite it. Just like when I'm writing my thesis, I'm rewriting my thesis topic, but I've had to go with what my thesis is. So it takes a lot of work. It's not easily done, but it's a skill that advocates should have. So issue framing, don't forget it. Thank you.
That was incredibly useful and interesting. I, for one, am looking forward to seeing which of my juniors in this room send me a draft with the most entertaining first line. Were there questions from the floor, or I think online there's an app you can put questions in? Jackie, Bianca's got a question from the floor.
In all of the examples you provided, I didn't see the usual expression in our submission, or it is submitted. And I would be grateful for some guidance on when to adopt that language and when not to.
Oh, well, I think it's just a natural thing when you're in oral advocacy, you say we submit X, but because in the written form, it's redundant. Okay. But you would say, the respondent makes the following 3 submissions. So I think just got to avoid having sort of leaden kind of prose. But you would say, the respondent makes these submissions because you are making submissions. So just use it sparingly, I think.
I think sometimes it's perceived as the polite way to put something forward, but I think I'm involved.
No, I think in oral advocacy you have to, punctuate a lot of what you say in our submission, our respectful submission. That's just the form and it's what expected. But I wouldn't do it every second sentence.
There are other
It's a difficult question to work out how to ask. Obviously, as barristers, we're charging for our time.
Yeah.
And as you've said today, this takes a lot of time. And what you can end up with is a 5-page document that was 10 pages and is now 5 pages because you've spent hours, possibly days, cutting it down. And then you have to charge for that document.
Yeah.
And the solicitor and the client are like, this document is 5 pages. You can easily see why they would quibble if you actually said how much you charge for, how long it actually took you.
Well, give them all the drafts.
I guess I'm asking, is there an do you understand it being, I suppose, an expectation that we're not charging for all of our time, or our solicitors and clients should just have to accept that this is how long it takes to write submissions to a particular page limit, or?
Yeah, well, I think the Deutsche Bank building's over there somewhere. I used to act for the junior for the late D.F. Jackson, and like he wrote concisely, and back in those days it was a dozen a day, and who would care if David Jackson wrote 3 pages and charge you 12,000. If they were gold, they were gold.
The juniors can do the same.
No, I doubt whether juniors can do the same, but if they're good, they're good. And ideally, you won't be reducing your 20-page thing down to 5 if you plan it and plan it. So I think your client and your instructor solicitor want to win the case. And you win the case with better submissions. And I'll tell you, as a judge, I'd prefer, after a trial, submissions that aren't 140 pages long. That at the most are 40 pages long. I mean, with some trials, submissions just have to be long. And, some judges put limits, our trial submission not to exceed 40 pages or whatever. I mean, if the quality is there, I don't care if they're going for 60 pages, but I don't like submissions where they're 20 pages, 40 pages, 160 pages that don't have the quality. They're just sort of slabbing out the evidence and it's all... So, and, when you read judgments from some courts and tribunals where it's just saying the evidence, the first witness called by the applicant, he said this, under cross-examination. Like, do you like reading those judgments? Well, I can tell you judges prefer to read shorter, concise submissions rather than rambling, long ones. So I would think there's always word limits in some courts, 10 pages, whatever. And my view, but that's just, I'm not a judge, I'm not being prescriptive. The submissions have to be as long as they have to be, but they shouldn't be any longer than they have to be. Maybe, the solution to your exquisite problem is that, the 10 pages that you came up with at the start, if they're of good enough quality, they stay, but the work goes in to the first page that captures the issue in the way that Llewellyn said. So, of course, it should be, well, my 70-page judgment should have been 35 pages, right? I wasn't charging by the hour. They got a 70-page or a 35-page judgment, so I wasn't charging by the hour. But I think if I, sense your problem, if you put the work in saying what issues, if you originally have 10 pages, and if that 10 pages doesn't have unnecessary stuff, repetitive stuff, if you can't really boil it down to less than 10 pages and the quality's there, then it's going to be a 10-page submission, not a 5-page submission, and you may be doing your client a disservice by trying to make it too concise. But it's got to have a first paragraph or two, the first page or two has got to capture what's coming. So the 10 pages you're talking about, I think we describe as the middle. Just make sure, apart from the middle, you've got a start, an opening that very briefly previews what's going to come in the following 10 pages. And if something's going to go for 10 pages, in other walks of life, people call them an executive summary. And, in most places where something goes, a report and goes for 10 pages, you have an executive summary. Well, we don't have executive summaries quite. But, just see somebody's overview or whatever, overview of the case, boom, boom, boom. And that's just a form of issue framing. So keep your 10 pages. They'll see you've done a lot of work in that 10 pages. You can charge for 10 pages. But make sure you frame the issue or the issues on page 1.
Can I just add, from a barrister's perspective on Amanda's question, I think sometimes as well, communication with your solicitors is the key, and sometimes that might involve you needing to educate them in the sense of saying, look, I acknowledge the submissions are only 5 pages or 10 pages, but, you know, a lot of work went into it. There was a lot of planning, there was a lot of thinking, and, you know, if you feel like it's not clear on the page the amount of work, you can tell them that. But as well, form your own assessments of what you think is fair for the work. You know, if you know you were spinning the wheels for a bit, procrastinating a bit, you know, I'm a great procrastinator when I don't have a deadline. And so I've been working on submissions the last few days, which I promised Jeremy on Monday, and I'm still working on them because I know I've been procrastinating. I'm not charging the client for that time, but at the end of the day, I will, you know, I know how long I've spent solidly thinking, and you charge what's fair. But I think you've got to make that assessment. I don't think a straight page limit is the fair way to assess that because a lot of work goes into it. But if you communicate with your solicitors often, that's a good way to sort of, you know, work out that issue of, well, what are they going to do when they get the bill? Was there a question somewhere else? I've got Jackie and one more here. Is yours an online one?
The question is, the Ghana framing paragraph includes a question at the end, whereas I write what I'm asking for at the end of the paragraph, we win, they lose, etc. Is there any particular advantage in asking the Ghana question? Is it just for rhetorical effect?
Well, it does have a rhetorical effect. Although Garner says that the question should be neutral, I think when you look at his examples, they're suggesting the answer. And if they do that, you don't need to say, therefore we win and you lose. That just follows. But I'm not being prescriptive about this. If you frame the issue and you want to say something different, you want to say, well, you know, there are 3 reasons why, you know, we win and there's 2 reasons why they're wrong, you say it. And you can say at the start, you know, for these reasons, the application should be dismissed. Nothing wrong with it, but it perhaps should be evident from the issue framing which way the case is going to go.
Is there a question here as well?
In the same way that you can use footnotes in written submissions to pass evidence fairly efficiently, are there techniques that you've used to do a similar thing in oral submissions?
I think in oral submissions, so long ago since I did oral submissions, but I've seen some barristers and often there's written submissions anyway, but often I've seen barristers just hand up an aid memoir, and that's an effective thing to do, and it might be an aid memoir that is, you know, in some dot point form or whatever, just dealing with matters that have been dealt with in oral submissions that mightn't have made the cut in the written submissions. So it might be in that form, but it might be the same sort of evidentiary thing. So if you might be in a court or tribunal where things are done on the fly and you don't have time to do written submissions, or the evidence is just emerged and you don't have time to get a transcript or whatever. So there's nothing wrong within the course of oral submissions having those aid memoirs, or say, you know, there's, you know, you'll find 3 places or 7 places in the transcript or 7 places in the evidence where there's evidence of this, and here's a note of them. So I think, you know, selective use of aid memoirs, you don't want to sort of have confetti, but I think that's a way of supplementing oral submissions in much the way you would have a footnote.
Any other questions? No, And I think all that's left is me to say a very big thank you. That was an incredibly informative CPD, and we are very, very grateful for your
You're
time
welcome.
and your expertise. Thank you, Peter.